Welcome back, guys, to the Creator Hub Studios, presented by Transcend Podcast Studio. I am your host, Travis, and I am here with...
Peter Nieves, IP attorney of 27 years, AI guy of 14 years. I run a law firm in intellectual property law, but I also run an educational institution, making everybody aware of issues that are happening with AI and protecting content creators and other groups.
Awesome. So, Peter, just, before we kind of dive into the meat of it, when you got into, the law side of AI, what got you into it?
Sure. So I've been doing intellectual property law, like trademarks, copyrights, patents, licensing, global IP portfolio management for a long time, right? Now, when AI came out, AI is not new. It's been around for a long time. So understanding how neural networks work and this kind of technology has been there for quite some time. ChatGPT came out in 2022. I think it was like November 2022. That technology is old technology. It's just a new graphical user interface, just some new way of interacting with old technology, essentially. So I already knew what legal principles applied to this. So if you, as an example, you're going to train a model, well, it's trained with content. Well, what areas of law pertain to content? Copyright law, trademark law. Those are often the areas that are pertaining to content. Also, privacy law. Those kind of things all pertain to content. So what I started doing is applying old law to what the world saw as a new technology. But I had been writing patents in the area for like 14 years. And so I already was familiar with this, but it was very new to the world. Like it had a new packaging. It was like an old car with a new package, and everybody went, oh, this is brand new. It's really not. It's just a new way of making it so you can interact with it, which is great. It's phenomenal. But old legal principles are being applied to it.
When it comes to AI and it raising a lot of the just legal questions around it, what are some of the misconceptions that people have?
Yeah, this is a great question, guys. And so one of the problems is people think you can put literally anything you want into AI. There are a number of problems with that. Number one, if you're taking someone else's content, you're uploading it into Midjourney, ChatGPT. That's called copyright infringement. Like if you take somebody's book and you upload it and you say, I want to make a variation of this where it's a different main character and I want this to happen in the story, you just uploaded someone else's copyrighted work. That's called copyright infringement. You made a copy of it. Okay. And then what you're producing is maybe considered a derivative of the original work. Well, that's copyright infringement. And so people weren't aware that what you're uploading, you need to be aware of what legal rights are associated with the content that you're uploading. In addition, people wanted to be able to own what they were creating using AI. Well, the federal district court and the Copyright Office have both come out to say that you can't own what's created using AI. However, you can own what's enhanced using AI. So if you can figure out how to enhance using AI versus creating using AI, you can actually own what you're creating, meaning you can get a copyright on what you produce for like $65 at copyright.gov. And now other people can't copy your stuff, which is important if you're creating original content, right? So one of the things that gets content creators very upset is when they spend a lot of time and effort producing something and somebody just grabs it, steals it, and they can't stop them. Well, copyright law prevents that. And so understanding how copyrights work and trademarks work actually helps you to work with AI. So this misconception of, well, I can enter anything I want. I can use all the results any way that I want. I can own anything that's created. That's just not true. On the output side, you have to determine how was the AI model trained? Where did that data come from? Was it scraped data? If it was scraped data, that means it's including copyrighted and trademark works of third parties. So you're getting potentially derivatives or modifications of other people's protected works. And you're now using that in your marketing campaign or in your book or something like that. You can get sued for trademark infringement, for copyright infringement, because you're not aware of what data was used to train the model. This is an issue with ChatGPT. This is an issue with Midjourney. The heads of these companies have all come out and said, yeah, we just scraped the internet and grabbed literally hundreds of millions of docs. We didn't even think about the copyright issue.
When it came to, there was the Studio Ghibli. I don't know if you're familiar with this, but Studio Ghibli is a creator, and a lot of people started entering prompts. Hey, create this like a Studio Ghibli artwork. with that, there came a lot of, distress from this artist. Have you seen that with other artists in this realm? And
Oh,
have you worked with
absolutely.
any?
I have, and I'm not allowed to say who they are, but yes, absolutely. Artists in general are really, some of them celebrate AI. A lot of them are very upset about AI. I'll explain why. A lot of their content was online when these engines went out and scraped content. So their content just got thrown into Midjourney, got thrown into a lot of these platforms without their permission. So now derivatives of their original works are going out to millions of people with them receiving no royalties at all. They're livid, like they're really pissed off about this. Well, there are ways that you can stop the scraping of your content online. There's things you can do on your website. There's different types of programs you can utilize to make sure that your content can't be grabbed online. It's our job as creators to know what are those things and to implement them so we can protect ourselves. If you're not familiar with how to protect yourself, like find out how and start doing that. But that is a big issue for a lot of artists, a lot of creators. There's the side where people are upset about this, but then there's a whole other side. Individuals that don't mind copies of their content. They just want to get a number of views. So they really don't care. They'll say, hey, look, use AI, clip my stuff, modify things all you want. As long as I'm getting tagged or somebody sees my face, I don't care because I'm getting more views. So you have to figure out what kind of content creator are you? Are you making revenue based on original content, or do you just want to get your face out? And if you just want to get your face out, then you probably don't care about a lot of these things. Or you're encouraging people to modify your work and to clip it and do all sorts of things to it. But you have to figure out which category you fall into.
And on the opposite spectrum, say I wanted to create a logo for my brand, and I used a subscription service to create it. Would I be the one at fault, or would the company be at fault for allowing myself to enter a prompt that created the logo for me?
Great question. Both. So here's the way it plays out. If you use, I'm not going to say the name of the company, but I'm pretty upset with the company. There's a company out there that basically scraped the federally registered trademarks of other parties, logos, and just things off the internet. And so you purchase a logo from them. You type in a word, it creates an image for you, and it creates like a design plus a word mark, right? It'll do all that for you. You pay $39, $29, $59, and you own it. And you think, oh, this is great. Like I didn't pay $2,500 to a developer or somebody off of Fiverr to create something. I didn't have to do that. I paid $59. This is great. I ran a demo on this live in one of my presentations in what I call the Content Creators Legal Bootcamp. And we paid for the logo. And I just went and did a federal registration like search on the USPTO website. It was a federally registered trademark of a third party. So not only are you getting a result that is legally a problem, you paid for the problem. I mean, this is just bad. And so it's our job as content creators, as professionals, to go out there and find out where is the content coming from that's using to train the model. So as an example, Adobe Firefly, all of the images on Adobe Firefly are licensed or original content or open source. So your chances of being sued for using a result or a logo that's created using Adobe Firefly is very, very slim, like extremely slim, because it's not using federally registered trademarks of third parties. It's using their own content. So it's our job to figure out what was used to train the model. What's going to happen with the results? Do I own the results? Some companies will say you can use it for business purposes, but you can't get a trademark on it. Look at Canva. If you go on the Canva, people are using Canva to create logos. You don't, if you're using their content and you're slightly modifying it, it specifically in their rules says you cannot own under trademark law what you created using our site. It tells you that, but people are doing it anyway. They're filing. So why is that a problem? That means anybody else who creates that same thing would be infringing potentially upon the trademark that you created or the logo that you created using Canva. So Canva said, no. You can upload your own stuff, modify it, and own that. But if you take our own image and you just decide to use that as a trademark and you file for a federal trademark application for that, that means everybody else who's using our site is going to infringe upon your trademark if they're using it for the same kinds of goods and services. We can't have that. So it's literally in their rules. It says you can't do that.
Gotcha. And so when it comes to, small businesses and, they're trying to cut corners, they're trying not to pay these developers or these, graphic designers to, create content or just create graphics, is this something that is always in the terms and conditions, or how can they know for sure whatever subscription or AI generating model they're using is safe for them to use?
That's a great question. Companies are starting to make it more readily available, this knowledge of what was used to train their models. Back in the day, they didn't make anything aware until all of a sudden companies like OpenAI got sued by the New York Times. They got sued in the United Kingdom for billions of dollars. And a lot of other companies have been sued since. Now they're making the public aware. They're saying, okay, look, our content, we created our database scraping, or we created our database with licensed content. So now it's a little easier to get this information. Mm-hmm. So it's your job. You need to look for this. On top of that, you can look in the terms and conditions and then the legal disclaimers of these sites. A lot of them tell you. They'll have information and they'll give you like these telltale signals. As an example, it'll say, anything you create using our site, we're not responsible for under trademark law or copyright law. That's telling you that they want you to know whatever you're creating, it's your responsibility, not ours. We're not liable. So me as a content creator, if I'm using a site that's indemnifying me, meaning they say if you get sued, we will pick up the case and we'll protect you. Like Google did that recently, right? So then I'm a little more comfortable using their site because I know if I run into a legal problem, I can push it onto their team, as opposed to having to spend tens of thousands, hundreds of thousands, millions of dollars getting out of a legal problem, right? These are not things you want to be thinking about as a content creator. So just ask yourself these questions. What data was used to train the model? Am I allowed to own what's created using the model? If you know the answers to those, you're about 80% of the way there.
So would you say that a lot of original content creators are kind of taking action now against AI?
I wouldn't say against AI. I mean, there's a right way to use AI. I use AI every week, and I'm a lawyer, and I work in an educational industry. So I do both, okay? And I use AI literally every single week. It's phenomenal. People aren't really against it. What they're doing is they're becoming aware that there's an issue, right? One thing I always tell people is if you think of AI like a scalpel, an AI scalpel in the hand of a surgeon can save lives. It can transform businesses. It can make you grow exponentially faster. You put it in the hand of a toddler, somebody's going to get hurt. They don't know what they're doing. They're going to make mistakes. They're going to either hurt themselves or going to hurt the people around them because they don't know what to do. AI is a tool. That's all it is. It's a tool. So you have to learn how to use it responsibly and learn what happens with your content when you upload it. If you're uploading your client's confidential information into ChatGPT, congratulations, you just made it available to the world. Well, if you're in the healthcare industry and you're uploading their personal information, you just ran into some legal problems because you violated HIPAA. You violated a lot of other rules. So you need to think about these things. What's happening with what I'm uploading? And then can I use the results? And then can I own what's created? Those are the things you should be checking into.
So is there a lot of evolving laws that are trying to adapt with AI now compared to, even 1 year ago?
Yes. So what's happening is that the courts are catching up with the technology. It's old law. Just to be clear, this is not new law. It's old law being applied to what's considered to be new technology. Okay. So as an example, something that happened a few years ago, there was a woman, Christina Casanova. So she filed for a copyright on a comic book. Okay. Now the images she created using a program like Midjourney. Right, so it was AI created. The text of the comic book she wrote herself, but she filed for a copyright with the Copyright Office for the entire comic book, not saying this is by AI, this is not by AI. Just filed it. She got a federal registration. Now, what does that mean? That means that she can stop anybody from copying her comic book, which is important. If you're selling it on Amazon, on eBay, you want to make sure people don't knock you off. If somebody does knock you off, you just give the federal registration number, file a complaint, and boom, the company pulls it, right? So she thought she was in a great position. Well, what happened? She started bragging. She was I'm one of the first people ever to use AI and get a federal registration. Well, the Copyright Office found out about it. They revoked her legal rights under copyright law. And they said, you have legal rights to your words, but not to your images. So now she has a copyright for the words, but not the images of the comic book. That means anybody can copy every single image within her comic book and she can't stop them. So the Copyright Office is catching up, but even the courts are catching up. There's recent case law in this exact area confirming what I said was going to happen like 3 years ago. It's basically just confirming that old trademark law and copyright law applies and privacy law applies to this area of law as well.
You said that you kind of called that out 3 years ago. Next 3 years or even 10 years in creative ownership, what do you think that is going to look like?
Sure. I think what's going to happen with the Copyright Office is they're going to allow more copyright applications on AI-created works. Right now, AI-enhanced works are being allowed to be registered as opposed to AI-created works at the Copyright Office. What does that mean to content creators? Like, let's say you create an online course and you want to make sure people don't steal it. You need to get it copyrighted, right? You file for it, $65, really cheap, okay? But let's say you use AI to do some of the work in there. These applications are being looked at the Copyright Office, and they're starting to allow more of these to register. The problem for a lot of prompt engineers, people who are creating their own prompts, they were saying, well, my prompt is so remarkably verbose. I'm really the creator here, not AI. The Copyright Office didn't want to hear it. Like they said, no, that's baloney. We don't care how verbose your prompt is. We're still not going to allow your copyright to be registered, right? And their rationale was a machine is doing the creating. That was their rationale. However, a long, long time ago, the Copyright Office actually allowed the copywriting of certain works that were created using a machine. Everybody has a phone. Your phone has a camera on it. If you pick up your phone and you just take a picture of anything, you own the copyright on that automatically. The law has said that. The federal district court has said that. The Copyright Office has said that. That's a machine. I mean, I don't know about your cell phone. I don't have a hamster inside of mine like in the Flintstones, like tapping and creating a slate. Like, it's a machine. So there's precedent saying that what's created by a machine actually can be copyrighted. AI kind of fits in that realm, but right now, the Copyright Office and the Federal District Court are saying, yeah, we don't care how verbose. We don't care if you say the specific color, the size, where the eyeball is, where the mouth is. We don't care. None of that's protectable. I think that's going to change within the next probably 3 to 5 years. I see that changing. I think what's going to happen is the Copyright Office is going to have to acknowledge there are millions of docs that are being created like immediately, and we have to figure out a way to figure out when is it the case that a prompt is so remarkably verbose that the rendered result should be protectable under copyright law. And I think that's coming. It'll definitely be within 3 years. I have no doubt about that. So, but that's going to change the whole world. Why? Because now you have companies who can automate the creation of certain things and they'll own everything that's created. So look at the 3D space, the virtual reality world. Imagine now that there's a company that has certain prompt engineers who create the right prompt to create a virtual world and then every derivative of that world. That means they're going to own that entire space. There's a lot of money in 3D virtualization and in like real life encounter through machines. A lot of money. It's an industry that's just growing and it's going to get a lot bigger, a lot bigger. Well, the people that figure out how to own what they create using AI are going to take a big portion of that space. Nobody's talking about that, but that's where I see that playing out.
And with that being a new industry, do the old laws still pertain to that?
They do, but what's going to happen is there'll be lawsuits that are filed based on this new technology, and then the courts will define how the old law applies to the new technology. It'll take litigators like myself, IP attorneys of 27 years, and even people that have done it less or longer, and we'll have to hash it out in the courts.
given a lot of great information on this and bringing a lot of awareness to AI and really just the caution that you should take with it. If there's one piece of advice that you can give to content creators right now, what would that be?
You got to follow people that know what they're talking about. You need to stop following people that have no clue what they're talking about, and they're just speaking about trends. Mm-hmm. That's fun. It's fun information. But if you truly want to grow as a content creator, you want to be more than a blip on the radar, like, oh, I had a good year and then crash. I have nothing left. If you want to grow, if you want to build a sustainable business, if you truly want to be a content creator that lasts, you need to follow people that know what they're talking about. As an example, like I've been doing this for quite some time. I'm not trying to plug myself. Mm-hmm. If you find somebody else who has the level of knowledge that I do, follow them as well. All right. But don't just randomly follow people that are talking about the legal issues and the ownership issues and the repercussions of using AI, the pluses and the minuses, if they truly don't know what they're talking about. You have to figure that out. And more people are becoming aware of this. They're seeing the lawsuits. They're seeing the OpenAIs and others. And now what's happening is people are getting sued. It's changed from the big multi-billion-dollar, trillion-dollar companies to now it's people who are using results. And so they're becoming aware. So now it's our job to find the people that know what they're talking about, follow them, watch them. If they're doing some kind of training, go to the trainings, like learn, because this information is very, very new.
And do you have any trainings or, seminars that are coming up that people can stay in touch with you?
Yeah, we have one that's literally happening in a week and a half. So it's called the AI Do's and Don'ts Masterclass. It's on August 27th to the 29th. If you go to aidosanddon'ts.com, sign up there. I'm training for 3 days online on Zoom. It's only 1 hour a day. If you want to ask me direct questions, you can in the VIP session. We're doing that there. But I'm training people for 3 days for $47. I mean, I bill at $600 an hour. Yeah. So we're going to make sure that you understand what's going on, what you can do, what you should never do. And we're going to answer some really tough questions because people are asking very tough questions. Like they're building their business based on AI. And they're saying, hey, is what I'm building on like sand or is it on a solid foundation? And we're answering the tough questions. We can't give you legal advice, obviously, and I'm not going to give legal advice, but I'll give guidance based on what's allowed and what's not allowed.
Cool. And as my final question is there anything that you recommend as a subscription model or anything that is actually safe for content creators to use?
For AI?
Yes.
Yeah, Personally, I like Adobe Firefly. I like that's great for creating images because all their content is licensed, open source, like their own created content. They're not going to sue me for using the results of something where I'm paying them a membership. I mean, that's a bad business model. Come to live in my house. Now I'm going to sue you for trespassing. Like that doesn't make sense, right? So that's one that I use. But I mean, to be honest, I'll use ChatGPT. I'll use Midjourney. I'll use everything. I'll use a number of programs, but I understand the limitations. As an example, I have certain AI programs that I'll use where I have an interview with somebody where there's not confidential information. It's just general discussion. Then what I'll do is I'll upload that into certain platforms, get a transcript of that, take that transcript, upload it into ChatGPT and say, hey, I just had a meeting on X, Y, Z. Can you create an email that hits the top 5 points and invites them to the next meeting that we're having? Boom, like literally a second and a half. What took me 2 hours before now is done. It's instantaneous. Like, why would you not do that? But what you're not doing is having a confidential meeting with a client, talking about their new invention and then uploading that into ChatGPT, because that would be an ethical violation. I would also run into violation of the patent statutory bars by disclosing something to the public. So you need to understand, what content am I using? Is it publicly available? Is it not? Do I need to maintain it confidential or not? And use the platform based on what you need to do. Awesome. And so if you can figure that out and master that, AI is amazing. Like it makes my life so much easier. And my team loves it. We use it in the law firm. We use it in the educational institution. It's just a matter of you need to understand the circumstances around the content that you're working with and use a platform that is amenable to that circumstance.
So ultimately, just taking the scalpel and becoming a surgeon.
Yeah, you need to become the surgeon. And if you do it well, you'll save a lot of lives. Gosh, this is ironic. So you'll save a lot of people. A lot of people not only be helped, but they'll tell other people around about it, which is what content creators want. They want more people following, more people learning, more people growing and building communities around that. And you can do that really well with AI if you do it the right way.
Awesome, Peter. Let the people know where they can find you.
Sure. Yeah. So, well, the law firm is nievesip.com. So that's the legal side. But with regard to the educational side, we just started doing social media stuff because so many people are asking us to get on social media as attorneys. So I did. So if you go to IP Mentor Instagram, IP Igloo Peter Mentor, you can see us there. And even if you type online on Google Peter and Patent, Peter Nieves and Patent, I'm all over the internet there. But as far as the training goes, aido'sandon'ts.com. I would get in as soon as possible.
Awesome.
Yeah.
Thank you so much, Peter.
Sure thing.